Madam, I am taking this question on behalf of the Prime Minister. The appointment of the new Attorney General is in accordance with Article 35 of the Constitution.
Ms. Sylvia Lim.
Supplementary question for Minister. My concern is actually regarding specifically Section 35, Subclause 4 of the Constitution. I'd like his comments on whether he feels that there is any issue with regard to the age of the new appointee.
Thank you, Madam Speaker, for allowing me to answer. No, Article 35(4) does not create an age issue for the appointee.
Ms. Lim.
Yes, Madam. I have a different view of the article, and I'd like to ask Minister whether he agrees that this could be a reading of Article 35(4). And my view is this. Article 35(4) provides that the AG may be appointed for a specific period of time. And it also says that subject to his being removed, he shall vacate his office at the expiration of the period, but subject as aforesaid, meaning subject to the removal clause, he shall otherwise hold office until the age of 60 years. And furthermore, the proviso to Article 35(4) states that the President has a discretion, if he concurs with the advice of the Prime Minister, to permit an AG who has attained the age of 60 years to remain in office. So my question is, the article does not seem to contemplate the appointment of a new AG who is more than 60 years old to assume the post.
I think that would not be an accurate reading. In fact, it would be quite an inaccurate reading. If you look at Article 35(4) carefully, it provides for two types of appointments in two situations. One, an appointment of an AG without a specific term. That can only be done when the appointee is under 60 years of age. There are two parts to 35(4). The second situation, in that first situation, the appointment ends when he reaches the age of 60. The second situation is when the appointment of an AG is for a specified term, say 2 years, 3 years, and so on. That person can be below 60, can be above 60, and the appointment ends when the term ends. And of course, in both cases, government may allow extensions beyond the age of 60 or beyond the specified term. The proviso applies in one of those situations when a person below 60 has been appointed, and then he is allowed to carry on beyond 60. Any other reading would be looking for a reasonable word, would not make much sense, because that would say that you can carry on beyond 60, but only if you have been appointed before you reach 60, and in which case then the age does not seem to be the relevant criteria. And if you look at past practice, Mr. Tan Boon Teck, the late Mr. Tan Boon Teck, held office until past the age of 63. At that time, the relevant provision stated age 55. Mr. Chan Sek-yong, who was AG as well as Chief Justice, was appointed in 1992 at the age of 54 and appointed for a 2-year term past the age of 55. And in 1994, the age in Article 35(4) was changed from 55 to 60. And Mr. Chan continued to hold office past the age of 60, and he was reappointed for a series of terms thereafter. Current Justice of Appeal, Justice Chow Hik Tin, was above the age of 60 when he was first appointed AG. He was 63 when he was appointed for a term of 2 years, and 65 when he left office. And we have had a number of AGs below the age of 60 who were appointed for a specified term. Mr. Walter Woon, the current Chief Justice, Justice Stephen Chong, Mr. V.K. Raja. All these appointments were in accordance with the Constitution, and the interpretation I have put forward, Madam Speaker, is something we have confirmed with the Attorney General's chambers.
Mr. Murali Pillai.
Sorry, Madam, may I ask?
In it, please.
Ms. Lim, you've already asked 2 clarifications. Clarification
Madam,
given.
I'm still not satisfied with the Minister's answer. May I just ask?
1 final clarification.
Thank you, Madam. Madam, I think the Minister would also note that there is an Article 35(5) where it is specifically provided that nothing that is done by the AG shall be invalid by reason only that he has attained the age at which he is required by this article to vacate his office. So there is an indication in the Constitution about the importance of the age, and some of the office holders that he mentioned earlier, I think they were sitting AGs appointed before the cutoff, save for Chow Hik Tin, which case I think was never adjudicated. So my question is whether the government would, in good faith, to clarify this matter, apply to court for an interpretation to see whether the government's view is correct.
That is quite ridiculous. The government has taken advice. I am satisfied. Anybody who reads it will be satisfied. If the member feels that there is something wrong, I would leave it to the member to apply. If the member is right, a number of anomalies, of course, Justice Chow Hik Tin's appointment as AG would then have been not in order. Secondly, if you look at Article 35(5), so according to the member then, if a person is above 60, then Article 35(5), since it only applies before the age of 60, then what happens to decisions taken by those people? You must read the Constitution with common sense. The Attorney General, I'm reading 35(4), may be appointed for a specified period, and that's the term appointment, and if he was so appointed, shall, subject to Clause 6, vacate his office at the expiration of that period. But subject as opposite, shall otherwise hold office until he attains the age of 60. So he clearly envisages 2 different types of appointments. And it's strange to ask the government, which has taken a view and has taken advice from AGC, I disagree with you, and therefore would you apply to court?